Welcome everyone to this session where we will learn about judicial review. Now, what is judicial review? Judicial review is the power bestowed upon the judiciary by the Constitution by virtue of which the judiciary can examine any legislative enactment or any law that the state, center, and any executive has passed. Each law needs to be within the ambit of the Constitution. If the laws violates the constitution or are beyond the power of the constitution or otherwise, then the court has the power to declare the law as unconstitutional and void. Background of the judicial review. We can trace the origin of judicial review from the United States of America in the case Marbury versus Madison. India has taken the concept of judicial review from the US Constitution, but it has adapted the concept to suit its version. The Constitution of India, under different article, has granted the power of judicial review to the judiciary. The power of judicial review was first established by Supreme Court in the case Sankari Prasad versus Union of India in 1951. What are the importance of judicial review? First, judicial review upholds the principle of supremacy of the Constitution, that is, rule of law. The provision of judicial review prevents the misuse of power by legislation and executive. It maintains equilibrium between the center and state, thereby maintaining a federal equilibrium. The provision protects the fundamental right of the citizen. The provision ensures that principle of the independence of the judiciary. What are the scope of judicial review? Well, judicial review is not absolute and it can be only used when a law is questioned on following ground. When the law violates the fundamental rights that are enshrined in the Constitution of India, when the law infringes any provision listed in the Constitution, when the enacted law goes beyond the power and the capacity of the officials that have enacted that law. As stated earlier, judicial review is not absolute. There are limitations of judicial review. Under Article 361, the President, Governor, and Raj Prabhuks are executed from any legal proceedings in a court of law with respect to the acts performed during the term of office. That is, the exercise of power by President or Governor cannot be subject to judicial review based on merit. Article 72 and 161 provide the power to President and Governor to grant pardon or suspend punishment, which cannot be altered or truncated by any court. Similarly, a money bill is beyond the power for judicial review. Rest other bills are within the ambit of judicial review. There are three types of judicial review. They are judicial review of constitutional amendment. Whenever a law gets amended, it is in ambit of the judicial review of legislation by parliament and state legislatures, expanding to the subordinate legislation, that is law passed by the legislature or state legislature, judicial review of the administrative action of the union and state, expanding up to the authorities under the state, that is judicial review of the administrative functions of the states and the subsidiary under it. Some of the features of judicial review are as follows. First of all, judicial review is the right that is possessed by both Supreme Court and High Court of the country in Article 32 and 226 respectively. Law made by the center and state both are subject to the judicial review. Judicial review is not automatically applied. It is used whenever a law is questioned. Judicial review is not suo motu. A court cannot itself take any law that needs to be examined. A writ or a petition should be filed. Judicial review is governed by the principle of procedure established by law under Article 21 of the Constitution. Under Constitution, certain article provides the power for judicial review. Article 13 provides that court can make any law that violates fundamental rights null and void. Article 32, the Supreme Court has power to issue writ to protect fundamental rights. Article 131 to 135 provide for the original and appellate jurisdiction of the Supreme Court. Article 136 provide special leave to appeal by the Supreme Court. Article 137 provides special power to Supreme Court to review any judgment pronounced or ordered made by it. Article 226 provide High Court the power to issue writ. Article 227 provide that high power of superintendence over all courts by the High Court. Article 372 subsection 1 provides establishes that judicial review of the pre-constitutional legislation. There are many more other articles that upholds the provisions of judicial review. However, there may be some problems with the judicial reviews, such as the judicial review limits the functioning of the government, the executives. It violates the limit of power set to be exercised by the Constitution when it overrides any existing law. There is separation of power, which gets into controversy due to judicial review. Judicial's opinion of the judge, once taken in any case, becomes a precedent and becomes a standard for ruling in other cases. Judicial review can harm the public at large, as the judgment may be influenced by personal or selfish motives. Repeated intervention of courts can diminish the faith of people in the integrity, quality, and efficiency of the government. There are various landmark judgments pertaining to the judicial reviews. They are Sanjay Singh versus State of Rajasthan, that in which the court held that constitutional amendment made under Article 368 are not within the ambit of the judicial review by the court. In IC Golaknath and other versus State of Punjab and another, the Supreme Court asserted that Parliament has no authority on the Article 368 to change the constitution or to take away or restrict fundamental rights. In Keshwananda Bharati was a state of Kerala, one of the famous landmark judgment. It was held that there were limitations on the amending power of the parliament and that the basic structure of the constitution could not be altered. In Indira Gandhi versus Raj Narayan case 1975, the Supreme Court held that the election of the president, vice president, and prime minister and the speaker of the Lok Sabha is beyond the scrutiny of the Indian courts and declared unconstitutional and void, though it also established that judicial review is one of the basic structure of the constitution. Thank you all for joining this session. Bye.